Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 5 of our new series entitled The Precedential Cases, the Medical Legal Game Changers. And I have a fascinating session in store for you today, which we'll get to in just a few moments. But before we do that, let's just take a couple minutes and review where we've come so far with the important cases that we've discussed in this program. In session number 1 of this program, we talked about the Escobedo versus Marshall's case. And the Escobedo case is noteworthy for 2 specific reasons. Number 1, the Escobedo case set the precedent for what qualifies as substantial medical evidence for the opinions and conclusions that you offer in your report. And I suggest to you that every single opinion and every single conclusion that you offer within the body of your report, that you qualify that opinion as substantial medical evidence, and we described exactly how to do that in that session. And secondly, and no less important, is the Escobedo case established the importance of the mechanism of injury in arriving at your apportionment approximate percentages. So as we know, our apportionment approximate percentages, meaning the percentage of the permanent impairment due to the industrial injury and the percentage of the permanent impairment due to other factors, our opinion has to be based on relevant facts. Well, what are the relevant facts, and what are some of the facts that are relevant to the apportionment determination? Escobedo told us that the mechanism of injury is perhaps the most relevant of all the relevant facts that relate to the apportionment approximate percentages, and we went into great detail as to that concept in that session. In our second video in this series, we talked about the Alvarez and Guzman cases, and really the Alvarez and Guzman cases literally blew open the constraints imposed by Senate Bill 899, which was passed in 2004. And the purpose of Senate Bill 899 at the time was to constrain and compress and reduce what were referred to at the time as skyrocketing costs in workers' compensation. And Senate Bill 899 had many citations, new rules, new regulations that had as their purpose to reduce skyrocketing costs. But the Alvarez and Guzman cases literally thwarted and frustrated the constraints imposed by Senate Bill 899, at least as relates to permanent impairment ratings that are provided for by the AMA guides, which are otherwise quite conservative ratings. The Alvarez and Guzman line of cases blew apart and blew the top off the otherwise teeny tiny and constrictive and restrictive permanent impairment ratings provided for under the strict application of the AMA guides. And in this session on the Alvarez and Guzman line of cases, we talked about exactly how to provide for an alternative impairment rating within the 4 corners of the AMA guides if you so decide that an alternative impairment rating is a more accurate description of the examinee's impairment than is an impairment rating provided for under the strict application of the AMA guides. And there's an exact recipe and formula for providing for these alternative impairment ratings, and we went over that in great detail in session number 2. In session number 3, we talked about the Cannon case, and the Cannon case was a fascinating case that basically provided an injured worker with a permanent impairment rating by analogy to a condition that he didn't have, by analogy to physical examination findings that he didn't have, but an analogy to limitations in activities of daily living that by analogy the examinee remotely had a limitation in activities of daily living remotely similar to another impairment rating in the AMA guides that describes a similar limitation in activities of daily living. So it was an analogy of an analogy of an analogy of an analogy. And it was upheld by the courts. So it was an absolutely fascinating case that really shed some light on what is possible for us as qualified medical evaluators in terms of providing for permanent impairment ratings for our examinees. So the Cannon case is an application of an Alvarez and Guzman alternative impairment rating, and it just shows us how liberal our permanent impairment ratings can now be under the Alvarez and Guzman decisions. And expanding upon the Alvarez and Guzman alternative impairment ratings, we talked about another case, the Kite case, in our next session. And the Kite case for the first time provided for a new method of really exploding permanent impairment ratings when an examinee has impairments of multiple body parts, which is to be distinguished from multiple impairments of the same body part. In the Kite case, the examinee had permanent impairments of multiple body parts. In the Kite case, the impairments involved the bilateral hips. And so in those cases where you have an impairment rating of multiple body parts, you can use the Kite case as precedent for adding the permanent impairments versus combining the permanent impairments using the combined values chart on page 604. And the Kite case set the precedent for huge permanent impairment ratings, because the permanent impairment ratings can first of all be based upon an alternative impairment rating under Alvarez and Guzman. Okay, so there's the first escalation of permanent impairment ratings. And then the escalation can be escalated by adding those impairments versus combining the impairments, which, as we know, combining impairments using the combined values chart on page 604 has a compressive or reductive effect on the final impairment rating, such that two impairments of 10% under the combined values chart might combine to a total of like 18%, whereas with adding the impairments, the final impairment rating is 20%. And this is just an example using small numbers. As the permanent impairment ratings increase, such as 20% plus 30% plus another 30% for another body part and a 30% for another body part, using the combined values chart, all of these combinations are impossible to reach 100% total disability because of the compressive and reductive effect of the combined values chart. But by simply adding versus combining the impairment ratings can easily exceed 100% permanent impairment, and thus provide for the injured worker a finding of 100% total disability. So the Kite case is what blows the lid off the combined values chart on page 604, which is asymptotic. The curve, the permanent impairment curve of the combined values chart, is asymptotic to 100%. No matter how many impairments you have, you cannot actually reach a 100% permanent impairment rating because the curve is asymptotic. It approaches 100%, but it never touches 100%, whereas with adding the impairments, you can easily exceed a rating of 100% permanent impairment. So the Kite case, like some of these cases that preceded it, provide for huge permanent impairment ratings. Today I want to share with you the Melgoza-Garibay case, and we'll talk about that in just a minute. You're going to find that to be fascinating. And then in our final session coming up next week, we're going to talk about some apportionment issues, and we're going to talk about your apportionment approximate percentages, and we're going to shed some light on some principles involved with providing for your apportionment approximate percentages by reviewing an historic case known as the Benson case, which tells us how to handle apportionment determinations when we're dealing with two or more injuries to the same body part, when those two or more injuries become permanent and stationary, at the same time. And if you think about that, sometimes if you have an examinee who has 2 injuries to the same body part and the examinee is receiving treatment, it's hard to distinguish and separate between the permanent impairment due to one date of injury to that body part compared to a separate date of injury for that same body part. And the Benson case gives us some illustrative principles as to exactly how to do that. So we'll get into that into our very next session. In today's session, I want to talk to you about the Melgoza-Garibay case. And the Melgoza-Garibay case is a fascinating case because, in my opinion, the Melgoza-Garibay case illustrates the liberal construction principle described in Labor Code 3202 to the nines. The Melgoza-Garibay case puts liberal construction on steroids and shows just how liberal construction can be applied to every single aspect of an examinee's case. And the Melgoza-Garibay case perfectly illustrates the differences in thinking between liberal-minded QMEs and conservative-minded QMEs. If you've been doing QME evaluations for any length of time, you're aware of the terms liberal versus conservative QMEs. And traditionally, these terms, liberal versus conservative, have been used to refer to QMEs as either applicant-oriented or liberal QMEs, and defense-oriented or conservative QMEs. And QMEs will tell you that they have one or the other type of an orientation when it comes to providing for their opinions and conclusions. Well, the entire system of workers' compensation is oriented towards the liberal end of the spectrum by law. It's Labor Code 3202, which we'll go over in a few minutes. And some qualified medical evaluators apply the liberal construction philosophy to every single aspect of their evaluation, and the Melgoza-Garibay case is an exact example of that very principle. So I have a fascinating discussion for you that is sure to open your eyes as to what's possible for you with your very next examinee. So with no further ado, let's begin today's discussion of Melgoza-Garibay versus Silverado farming. Okay, so understanding the Melgoza-Garibay case begins with an understanding of liberal construction as that applies to California workers' compensation. So let's begin with a discussion of liberal construction, and in so doing, we're going to refer to California Labor Code, Division 4 of the Workers' Compensation Laws. So we're going to go to Chapter 1. And specifically, we're going to go to Section 3202. So this is Labor Code 3202. Labor Code 3202 is contained within this book. This is a book entitled The Workers' Compensation Laws of California. And I just want to know, can you see the size of that book? Can you see this book? This book has approximately, I'm not even going to the end, but I'm at page 1829, and these are all the laws that relate to California workers' compensation. Well, Labor Code 3202 tells us that this division, it says this division and Division 5. So when it says this division, it's referring to this division, which is Division 4. Okay? So let's go to the book and let's open up Division 4. Division 4 is right here. Can you see that? Division 4, Workers' Compensation and Insurance. So this is Division 4. It begins with Labor Code 3200, and we'll turn the page, just the very next page, to Labor Code 3202, which is referred to liberal construction of Division 4 and Division 5 right here. liberal construction of Division 4 and Division 5. And it says, just what you see there on the screen, it says this division and Division 5 commencing with Section 6300. So this is Code 3200. Division 5 begins with Section 6300. So that's approximately 2,800 codes in Division 4 before we get to Division 5. Okay? I just want to impress you with the magnitude of the numbers of laws that this single phrase applies to. It says this division, all these divisions shall be liberally construed by the courts, that is, with the purpose of extending their benefits for the protection of persons injured in the course of their employment. So here's Division 4. Division 5 begins several hundred pages later and continues all the way through hundreds and hundreds of pages to terminate hundreds of pages later here on page 357 with the final code being Labor Code 7967. So we go from 3202 to 7967. All of these laws in these divisions shall be liberally construed for the purpose of extending benefits to protect persons injured in the course of their employments. So all of the laws in California workers' compensation give the tie to the runner. When the injured worker comes upon a gray area in some determination in their case, the courts liberally construe the laws so as to provide benefits for persons injured in the course of employment. Now, notice that the law states that this philosophy extends to the courts. Does it say that this philosophy extends to qualified medical evaluators? It does not say qualified medical evaluators. It said that this liberal construction is applied by the courts. But some qualified medical evaluators feel that their philosophy is dictated by the liberal construction code described in Labor Code 3202. And this case, the Melgoza-Garibay case, applies liberal construction at every choke point, at every juncture, at every decision-making fork in the road. The qualified medical evaluator decided to opine heavily in favor of the examinee for the purpose of providing benefits to the examinee. Now, when we think about the important financial crossroads involved with the cases that we evaluate, what are those crossroads? Those crossroads primarily involve causation, which is AOE-COE, which without a liberal construction philosophy of AOE-COE, the pocketbook to benefits may remain closed, where a liberal qualified medical evaluator will opine for FOR industrial injury, whereas for the same set of circumstances, a more conservative-minded qualified medical evaluator may opine against industrial injury, where one qualified medical evaluator will open the checkbook to benefits, the other qualified medical evaluator will close the checkbook to benefits. So we have a spectrum of liberal versus conservative qualified medical evaluators at the AOE-COE junction. What are some of the other junctions? How about the permanent impairment junction? Some qualified medical evaluators will provide a very high permanent impairment rating, whereas other qualified medical evaluators for the same examinee see the examinee through more conservative glasses and will provide for a modest or a low permanent impairment rating at the permanent impairment juncture. What about the apportionment juncture? Liberal-minded qualified medical evaluator will provide for a very high percentage of the permanent impairment to be due to the industrial injury and a very low or no impairment to be due to other factors, whereas a conservative-minded qualified medical evaluator will do exactly the opposite and will provide for 0% permanent impairment due to the industrial injury and a very high percent, maybe as much as 100%, to be due to other factors. So there's a spectrum of liberal versus conservative QMEs, and the liberal construction philosophy is adopted by some qualified medical evaluators at every single one of these junctures, and that's perfectly illustrated in the Melgoza-Garibay case. So let's talk about some of the facts surrounding this case. Okay, so the injury that we're going to talk about related to Melgoza-Garibay case was not her first industrial injury. Miss Garibay had a 2007 industrial injury while working for a hotel chain in the Napa Valley, and this injury involved multiple body parts, such as the spine, such as the back, such as the shoulders, plural. This is plural, bilateral shoulders. And this case settled by way of a compromise and release in 2011. So as we know, a compromise and release is not exactly the same as a permanent disability award as relates to subsequent industrial injuries and your apportionment determination. But it just bears repeating that she had a prior industrial injury for which she received compensation by way of a compromise and release. Well, then she filed a post-employment cumulative trauma claim with another employer in 2015. So it's not clear in the history what happened between 2011 and 2015, but she was performing seasonal work with Silverado Farming from 2014 through April 2015, and then work with Silverado Farming concluded in April 2015, and she continued from April 2015 to her last day of work, which was October 9, 2015, with Rios Farming. So for some reasons that are not described in the case itself, she filed a cumulative trauma claim for the period ending April 9, 2015 with Silverado Farming, with no claim filed versus Rio Farming, and it's not clear as to what that reason is, but what is clear is that she continued working after April 9, 2015. She continued working now with Rios Farming. So the season had ended with one employer in April, and she continued with seasonal work with another employer, but the cumulative trauma period was filed against Silverado Farming, perhaps because they were the party that was insured, although I'm simply speculating on that. Okay, and this industrial injury was for the upper extremities involving the wrists and the hands. Okay, so here's some of the important timelines of the case. She had her first qualified medical evaluation on 3/3/16. So the claim was filed at some point after the conclusion of seasonal work with Rios Farming. So this qualified medical evaluation was for the purpose of determining AOE-COE and for the purpose of determining if and indeed an industrial cumulative trauma injury did exist and did occur with Silverado Farming. Well, shortly after this, Ms. Garibay had right wrist surgery on March 29, 2016, and so of course the examinee would not yet be permanent and stationary for quite a while, perhaps as long as 12 months, according to some sections in the AMA guide, specifically in the sections regarding carpal tunnel surgery. So interestingly, the qualified medical evaluator then evaluated her approximately 10 months later, not quite a year later, but about 10 months later, on February 3rd, 2017, and paradoxically, the qualified medical evaluator declared that she was not yet PNS, And he provided an opinion. Again, he stated that it's my reasonable medical opinion, based on a reasonable degree of probability, that the bilateral wrist and hand complaints related to the injury through cumulative trauma 82616 have an industrial basis. And all we have in this case to reference is the actual case itself. So it's not clear to me where this date of 82616 comes from. And it's referenced only one time in the entire case, so I'm not sure what the Qualified Medical Evaluator is referring to here. But he states that in his opinion, the bilateral wrist and hand complaints is related to the cumulative trauma injury. And so here he opines for FOR, AOE, COE. Now again, all we have is the case to reference, so it's not clear as to what his reasoning is as to why the hand complaints had relation to Silverado farming and was not in any way related to working with Rios farming, and is not related to any past employment with Heritage Resorts or any other employer. But he opines in this case that the examinee should be provided with workers' compensation benefits. And here the Qualified Medical Evaluator applies liberal construction to open the claim and provide benefits to Ms. Garibay. Now, another Qualified Medical Evaluator familiar with post-employment cumulative trauma claims may not have opined so liberally, and in fact may have opined against industrial injury, which would have shut this case down right here at this very juncture, which is the AOE-COE juncture. So here is the first application of liberal construction. This time it's at the AOE-COE juncture. Okay, and then later, another year later, on February 6, 2018, the Qualified Medical Evaluator opined now, approximately 2.5 years after the last industrial exposure with the insured, that now the examinee is PNS. So certainly by February 2018, the examinee had certainly received probably the entirety of 2 years of total temporary disability benefits, which is the maximum allowed by law, prior to being declared permanent and stationary. So in this case, by opining for industrial injury, Qualified Medical Evaluator again applied liberal construction to provide benefits, in this case the entirety of 2 years of total temporary disability benefits, and this is the second application of liberal construction in this case. Now, in the Qualified Medical Evaluator's permanent impairment report on 2/6/18, he provided for a diagnosis of bilateral wrist pain with flexor compartment arthrosis, and this is the exact language as it's described in the case. So I'm not sure if the pain is in the flexor compartment or if there's flexor compartment arthrosis, but this is the diagnosis as it's described in the case. She had bilateral carpal tunnel syndrome, which was post-decompression on the right, and it was unoperated on the left, and some form of myalgia, and it's not clear which parts of the body are involved with that myalgia. But he provided for a permanent impairment rating, and again, that permanent impairment rating is not described in the case, although we'll go over a couple of the options that are possible for this type of a case. But he stated that it is my opinion that a strict whole person impairment rating would not be an accurate measure of this patient's permanent disability, and he bases this on my clinical experience and in consideration of the effects of the residuals of the work injury on the patient's activities of daily living. Now, we don't have reference as to what it is about the doctor's clinical experience that causes him to opine that the strict rating is not accurate. And we don't have references as to what are the examinee's limitations to activities of daily living. All we have are these quotes from the case. But the doctor apparently feels that a permanent impairment rating under the strict application of the AMA guides, which again are quite conservative, are not an accurate representation of the examinee's permanent impairment. And it's not clear exactly what his reasoning for that determination is. So in the body of the case, the courts tell us that Dr. Shaw believed that the strict application of the AMA guides to the evaluation of permanent impairment did not result in an accurate description of the applicant's impairment, given the impact of her symptoms upon her activities of daily living. He explained that a more accurate description of applicant's disability would be based on the fact that she had lost half the use of her right wrist and she had lost 20% of the use of her left wrist. So as we're going to see, this is an alternative impairment rating under Alvarez and Guzman, which is going to dramatically increase the examinee's permanent impairment rating. And here, this is the Qualified Medical Evaluator's third use of the liberal construction philosophy. Whereas another Qualified Medical Evaluator may have felt that the permanent impairment rating under the strict application of the AMA guides was a more than adequate description of the examinee's permanent impairment, here the Qualified Medical Evaluator applied liberal construction to provide for a much higher permanent impairment rating. So let's take a look at some of the upper extremity impairments that are described by the AMA guides. Okay, so here in the left-hand column, these are the impairments, the upper extremity impairments that are described in the AMA guides. So the AMA guides describe amputations, digital nerve lesions, abnormal motion. In this case, we would be talking about motion of the wrist and the hand. Talks about peripheral nerve disorders, talks about vascular disorders, talks about other disorders, and also not shown on this table, I believe, is impairments due to loss of strength. That must have been cut off in this chart. Well, anyway, let's see. Amputations does not apply to Miss Garibay under the strict application of the AMA guides because she did not have any body parts amputated. Digital nerve lesions does not apply. Does abnormal motion apply to Miss Garibay? Well, it could apply. It could apply if she has some loss of range of motion of the wrist, which we don't know by reviewing the case. She could have some loss of finger motion of the hand or the thumb, but we don't know because it's not described in the case. But this is an impairment that could apply to this particular case and could provide for some small impairment ratings if indeed she had some loss of range of motion. The peripheral nerve disorders could apply to Miss Garibay, and particularly in the peripheral nerve disorders section of Chapter 16, there's discussion of carpal tunnel syndrome on page 495, and carpal tunnel syndrome can provide for a minimum of 0% upper extremity impairment to a high of 45% upper extremity impairment. If the median nerve sensory and motor function is completely abolished, the examinee would qualify for as high as 45% upper extremity impairment. Now make note that that's an upper extremity impairment, which would then be converted to a whole person impairment by multiplying by 0.6. So a 45% upper extremity impairment would be approximately a 27% whole person impairment, which would be the maximum due for a carpal tunnel type of situation. Vascular disorders does not apply to Ms. Garibay. And the other disorders such as carpal instability, constrictive tenosynovitis, joint instability, digital lateral deviation or rotational deformity, none of those applied to Ms. Garibay. So in this particular example, the possible impairments that apply to Ms. Garibay would involve loss of motion and any peripheral nerve disorder, which would likely result in some low upper extremity impairment rating and even lower whole person impairment rating. And specifically for carpal tunnel syndrome, the permanent impairment ratings for your typical post-surgical decompression of the carpal tunnel generally range from 0 to 5%, and we'll review that in just a few moments. But let's take a look at how Dr. Qualified Medical Evaluator considered Ms. Garibay's permanent impairment rating. Okay, so here we have a diagram from Chapter 16 of the AMA guides, and the court told us that the Qualified Medical Evaluator considered that Ms. Garibay had lost half the use, which is 50%, of her right wrist, and 20% of the use of her left wrist. So taking a look at this diagram, we can learn that if the examinee has a complete amputation at the metacarpal phalangeal joints and loses the entire function of the second through fourth fingers of the hand, that qualifies for a 54% whole person impairment. So if we simply consider that the Qualified Medical Evaluator was using that impairment rating to consider the loss of function of the wrist, we could see that a 54% whole person impairment times 50% loss of use would equal a 27% whole person impairment rating, about the same as the highest permanent impairment rating provided for by median nerve dysfunction associated with carpal tunnel syndrome. And then 20% loss of use of the left hand amounts to a 10.8% whole person impairment rating. So in providing for a increased permanent impairment rating using an alternative impairment rating, Qualified Medical Evaluator again employed his third application of liberal construction. Then, if we took simply those high impairment ratings provided for under an alternative impairment rating under Alvarez and Guzman, which in and of themselves are much higher than the strict impairment ratings that would be provided for by the AMA guides, if we took those and we combined those using the combined values chart on page 604, 27 with 11 combines to 35% whole person impairment, a reductive effect of 3% whole person impairment rating. So using the combined values chart reduces the final permanent impairment rating by 3%. Well, what did the Qualified Medical Evaluator have to say about the use of the combined values chart? We'll take a look at that in just a minute. But before we do, let's see how the alternative impairment rating, by analogy to the direct estimate method, let's see how that compares to the typical rating provided for by the AMA guides associated with carpal tunnel syndrome. So in Chapter 16 on page 495, the guides tell us about permanent impairment ratings associated with carpal tunnel syndrome. And they tell us that if after an optimal recovery time, now the AMA guides further tell us in the later section related to strength, I believe it's section 16.8, they tell us that an optimal recovery time following carpal tunnel syndrome release surgery is about a year. Well, Ms. Garibay, she had approximately 2 years following the date of her surgical procedure, which would certainly qualify as an optimal recovery time. So after an optimal recovery time following surgical decompression, and if an individual continues to complain of pain, they continue to complain of paresthesias, and they continue to complain of difficulties in performing certain activities. In other words, they're having symptoms. Okay, so many times carpal tunnel syndrome surgical cases have a resolution of symptoms. That's the purpose of the surgery, correct? Is to resolve the problem, is to correct the problem, is to restore the function of the median nerve, is to decompress the median nerve. So a certain number of examinees, however, will continue to report symptoms following the surgical decompression. And for those cases, there are 3 possible scenarios that can be present. So this is what the guides tell us under the strict application of the AMA guides. So for example, examinee number 1 will have positive clinical findings of median nerve dysfunction. So what would that be? That would be an examinee who had positive Phelan's test, positive reverse Phelan's test, maybe a positive Tinel sign, maybe some sign of dysfunction or loss of sensation of the sensation in the distribution of the median nerve, maybe some atrophy of the thenar eminence. Okay, they've got positive clinical findings of median nerve dysfunction, and they have conduction delays on nerve conduction velocity testing. This type of an examinee, they tell us that the impairment due to residual carpal tunnel syndrome is rated according to the sensory and or motor nerve deficits described earlier, which, as we stated earlier, could qualify for as high as 45% upper extremity impairment in a case of complete dysfunction of the median nerve. Okay, so we don't know what her clinical findings were. We don't know if she had nerve conduction velocity testing. We don't know what her sensory and motor deficits are. We simply know that the doctor felt that impairment rating according to this method was not an accurate description of her true condition. Okay? Now, the second type of an examinee who's had carpal tunnel syndrome decompression is a person who has normal sensibility, in other words, normal sensation in the distribution of the median nerve, and has normal thumb opposition strength using the opponent's pollicis muscle, right? Median nerve innervated muscle. They have normal opposition strength, but they have some findings of abnormal sensory and or motor latency, or abnormal EMG testing of the thenar muscles. This is an examinee who has some residual carpal tunnel syndrome present and an impairment rating not to exceed 5% of the upper extremity may be justified. Now, this is an extremely small permanent impairment rating, 5% upper extremity. That's only 3% whole person impairment. And this, this permanent impairment rating is simply provided for an examinee who has abnormal electrodiagnostic studies. This is an examinee who has normal physical examination findings, but simply has some findings, residual findings on electrodiagnostic studies. And for that, the AMA guys provide for a tiny permanent impairment rating of only 3% whole person impairment rating. Now, this case, the Melgoza-Garibay case, we don't know what the physical exam findings are, But is it likely that she had normal sensibility? Is it likely that she had normal thumb opposition strength? Apparently, the carpal tunnel surgery was uncomplicated, so perhaps this could be an accurate description of her impairment rating under the strict application of the AMA guides. But the Qualified Medical Evaluator felt that this was not accurate. Finally, the third type of examinee is an examinee who has normal sensibility, normal sensation due to two-point discrimination and Semmes-Weinstein monofilament testing, had normal thumb opposition strength, and has normal electrodiagnostic studies. Therefore, there's no objective basis for an impairment rating, no objective basis. Despite the examinee's subjective complaint of symptoms, there's no objective basis for an impairment rating. So according to the strict application of the AMA guides, unless the examinee has some residual damage to the median nerve that could be detected on nerve conduction velocity testing and supported by positive physical examination findings, in the absence of those findings, the permanent impairment ratings for carpal tunnel syndrome are extremely, extremely small. But in this case, the Qualified Medical Evaluator opined that these small impairment ratings were not an accurate description of the true impairment. And in this case, and in this example, Qualified Medical Evaluator applied liberal construction to provide for a much higher permanent impairment rating. So we're beginning to see how the multiple applications of liberal construction are compounding in this case. The Qualified Medical Evaluator first applied liberal construction in opining for industrial injury. That began the supply of benefits for Ms. Garibay in the form of up to 2 years of total temporary disability in the form of medical treatment, including a surgical decompression of the right wrist. Number 3, in applying liberal construction to the permanent impairment rating, the Qualified Medical Evaluator took what would otherwise be very tiny or non-existent permanent impairment ratings and provided for significant and high permanent impairment ratings, as high as perhaps 27% whole person impairment for the right wrist, and perhaps as high as 11% whole person impairment rating. But then the Qualified Medical Evaluator applied liberal construction again, a fourth time, by jumping outside of the combined values chart and using the kite case as a precedent for adding the impairments versus combining the impairments. And if we read from the case, he states, I would refer the parties to the kite case, Kite versus East Bay Municipal Utility District, where the kite decision is used for synergistic effect of one hip injury on the second hip injury. Well, he states, regarding bilateral upper extremity injuries, I do believe synergistic effect is in effect in this case. Now, he does not explain how synergistic effect is in effect in this case. He does not cite examples as to why he believes that there is a synergistic effect. He simply references the kite case and makes an analogy to the kite case without much in the way of explanation as to his reasoning to support a synergistic effect. He states that based upon this Workers' Compensation Appeals Board panel decision, which has withstood a petition for reconsideration, I would agree that the bilateral upper extremity impairment, after apportionment and after adjustment for age and occupation and for diminished future earning capacity, that these impairments are additive and should not be subjected to the combined values chart, which, as we saw, resulted in 27 and 11 combined to approximately 35%, whereas using simple addition would qualify for, I think it came to 38%. So the combined values chart had a reductive effect of 3% whole person impairment, and this is the fourth application of liberal construction in this case. This is a qualified medical evaluator who is liberally construing every single possible decision making, every possible decision in the favor of providing benefits for Miss Garibay. So we've got liberal application, liberal construction times 4. Let's see what the qualified medical evaluator has to say now about apportionment. He stated in his final report that he supposes that final apportionment would be up to the judge, also known as the trier of fact, to make such a determination. However, there should be no false illusions that the injury presentation on this patient was from a lifelong work exposure. Well, if there's a lifelong work exposure, do you think that there should be some apportionment to relieve the current employer of some of the liability for the impairment rating, which is due to a lifelong work exposure with multiple employers? It would seem that there should be some apportionment in that case, especially if there's arthrosis of the wrist joint, which was described on the original diagnosis. Those degenerative changes, it would seem, would be responsible for at least a portion of the current impairment. But he tells us that there's a challenge with apportionment, and that challenge is trying to divide such disability, is dividing it up based upon a reasonable degree of probability. That's very difficult, and I have to agree with him that it's very difficult in coming up with apportionment approximate percentages with substantial medical evidence that qualifies, with an opinion based on reasonable medical probability that qualifies as substantial medical evidence. But he does tell us that it appears that at least she's able to continue working. He says, I've also considered the primary treating physician's input as well. And he says, therefore, it's my opinion, based upon a degree of reasonable medical probability, that 0% of the permanent disability in this case is due to the industrial injury of her prior industrial injury, wherein she received a compromise and release. So he did consider the fact that she had a prior industrial injury, at least to her back, spine, and upper extremities. He therefore concludes that it's his opinion that 100% of the permanent disability in this case is due to the industrial injury of 10/15, which is the last day of all employment, because the patient states she has not worked in any capacity since 10/15. So here, even though the examinee continued to work only for the defendant of record, which is Silverado Farming in this case, she only continued to work for Silverado Farming through April 2015. He describes a cumulative trauma injury extending through 10/15, now with a different employer. And he provides for 100% of the permanent disability to be due to those exposures with both of those employers. So here, Qualified Medical Evaluator makes his fifth application of liberal construction in providing for 0% impairment to be due to other factors and 100% of the permanent impairment to be due to employers. And he's not specific as to who those employers are, but we know that the case was advanced only against Silverado Farming. So, doctors, can you see some of the uncertainties that exist and the poor explanations that are described in the case, at least to the extent that we have the case available to us and the details that we have available to us? Can you see the multiple holes in the reasoning of the Qualified Medical Evaluator, and can you see how the defense attorney would have multiple options for attacking the Qualified Medical Evaluator's opinions and conclusions in this case? Well, unfortunately, the defense attorney did not do a terrific job in questioning the Qualified Medical Evaluator about some of these opinions and conclusions, and the case and the Qualified Medical Evaluator's conclusions were upheld for liberal construction to AOE-COE, liberal construction based on the permanent impairment rating, liberal construction applied to adding versus combining the impairments according to the Kite case, and then finally liberal construction as applied to the apportionment determination. Okay, so doctors, let's review some of the principles of this case. So this case involves multiple applications of the liberal construction philosophy. And it appears, at least from reading the case, that at every decision-making juncture, the Qualified Medical Evaluator decided to opine in favor of the examinee. He applied liberal construction for the benefit of providing, for the purpose of providing benefits for Ms. Garibay, who was presumably injured in the course of her employment. So, first of all, the Qualified Medical Evaluator applied liberal construction in opining for FOR, industrial injury, in a case which otherwise qualifies as a controversial case because it's a post-employment cumulative trauma claim, which, as we know, according to the 2017 RAND study, that many of these claims are forwarded for disingenuous reasons. So, by opining for industrial injury in an otherwise controversial case, the post-employment cumulative trauma claim for musculoskeletal injury, okay, this isn't an occupational disease such as asbestosis or heart disease or some of these other considerations that we consider the occupational diseases. This is a musculoskeletal complaint. This opened up the provision of benefits for this examinee, and this examinee was able to obtain total temporary disability benefits, which were huge in this case. They were huge. They extended for the duration of 2 years, which is the maximum allowable by law. So those benefits alone were huge. It provided for huge medical benefits, including a surgical procedure and all of the conservative medical treatments that preempted the surgical procedure. So those benefits were huge. And then it provided for a huge on top of huge permanent impairment rating for not just the right wrist, but for the bilateral wrist. And in providing for a permanent impairment rating, Qualified Medical Evaluator again provided another layer of liberal construction by using an alternative impairment rating versus a strict impairment rating by invoking Alvarez and Guzman analogies under the direct estimate method of rating permanent impairment. And then he provided another layer, another layer of liberal construction by adding versus combining the impairments. And can you see how at every possible decision-making juncture, this Qualified Medical Evaluator just looked in favor of the examinee or the injured worker. And then he finally applied liberal construction on the apportionment determination by finding no apportionment to other factors, even though Ms. Garibay had had a lifelong work exposure and a lifelong involvement of repetitive and heavy upper extremity motions. He found no apportionment to other payers, other employers, or he found no apportionment to require Ms. Garibay to pay for her portion of the permanent impairment by providing for a certain percentage of apportionment to other factors, such as degenerative changes, in which case Ms. Garibay would have paid for that portion of the impairment herself. Okay, he found no apportionment and 100% of the liability for all costs, including the permanent disability rating, went with the employer, which was Silverado Farming. Well, for whatever reason, the defendant did a poor job rebutting these issues, did a poor job rebutting AOE COE, did a poor job rebutting the permanent impairment rating. He did not depose the QME. They did not ask for a supplemental report from the QME. The defendant made no contest regarding the apportionment determination, and therefore a huge disability rating of 61%. 61%. This is probably composed of the 38% whole person impairment rating, 27% for the right wrist, 11% for the left wrist. Those added together totaled 38%. 38% impairment rating was then adjusted for age and occupation at the disability evaluation unit and came up with a final disability rating of 61%. And this case settled by way not of permanent disability award, but by way of compromise and release, which was Ms. Melgoza Garibay's second such compromise and release within less than, I think, an 8-year period of time. So, doctors, I hope this helps you. This shows you some of what's possible for you as a qualified medical evaluator when it comes time to providing your opinions and conclusions. You know, at every fork in the road that we face difficult decisions, and we're uncertain as to which way to take our decision-making process. Well, some qualified medical evaluators consider themselves to be more liberal qualified medical evaluators, and some qualified medical evaluators consider themselves to be conservative qualified medical evaluators. And certainly the most liberal of the qualified medical evaluators opine in favor of providing benefits for the injured worker at every benefit decision-making junction. So in this case, a more conservative qualified medical evaluator may have opined in the very beginning here differently, in that he or she would have opined against industrial injury, in which case none of these benefits, including possibly the largest of which was probably the total temporary disability benefits, in that case none of these benefits would have been provided for the injured worker for a case, a post-employment cumulative trauma case, which were otherwise considered to be cases that are renowned and known to be retaliatory type of claims, very common amongst seasonal workers who find their work and their source of income being terminated very shortly. So this gives you an example as to what's possible for you as a qualified medical evaluator, and these are some options that you have available to you with your very next examinee. So in our next session, we want to conclude with some discussion about apportionment principles, and we're going to talk about the Benson case and how to arrive at some apportionment approximate percentages that qualify as substantial medical evidence in those cases where your examinee has had multiple injuries, especially to the same body part. So that's going to tie together a lot of the principles that we've already established throughout sessions 1 through 5 of this program. So doctors, I hope this helps you, and I hope that you learned a lot that you can apply to your very next evaluation. So for today, I want to thank you for joining me on this discussion. I look forward to being with you on our very next discussion, as well as we conclude our series on the precedential cases, and these are the medical legal game changers. For now, I'm wishing you best of success in your career as a qualified medical